Forward TV. The world is thinking.
Hello everybody, I'm Tessa Mayes. I'm an investigative journalist and I've organised this session for a good reason. And the reason is that for some time myself I've been investigating how various laws have created a new authoritarian relationship between the state and individuals, and between individuals and other individuals, between each other. While a lot of my own investigative colleagues have gone undercover, for example, to expose those whose acts are illegal under many new laws, such as policemen making off-the-cuff remarks, which could be illegal under race hate speech laws, personally I feel what's more important these days is to start investigating the new laws themselves. In this case, investigate the race hate laws on the grounds that surely we should have a right to free speech in a democracy. And in recent years, British society has become increasingly litigious. Both the government and the public, in fact, have increasingly turned to the law to resolve problems. In fact, Prime Minister Gordon Brown has beaten even his predecessor's record, introducing 2,823 new laws at the last count during his first year in office. And that's saying something, because it was Blair that had the sort of reputation for being an over-obsessive lawmaker. This is the highest record for lawmaking by anyone at number 10, and 40% higher than the annual average created by even Margaret Thatcher. Meanwhile, disputes between neighbours, and often very, very trivial harassment cases, for example, are increasingly likely to come to court. So not just being resolved on the street corner between friends, relatives and neighbours, but to come to court. And this legalistic approach to social and political problems is causing a lot of disquiet, not only now, after many years of people experiencing the hard end of these laws in their personal lives, but also within the legal profession itself. There is disquiet in two main areas. Critics are questioning whether fines and imprisonment, which is often what happens when things come to court, that's how they're resolved. Are these always the answer to interpersonal problems such as harassment or people talking offensively to each other? The other area that we want to look at in today's discussion is also the shift in the principle of justice itself. What does it mean to have justice in the society? What does justice mean? And one of the disturbing trends, which has been hotly disputed within the legal profession itself, is the idea of victim-centred justice. For example, the drive to increase convictions in rape cases. Sounds good in practice, but is it always on a fair justice basis? Or are there problems for someone who's innocent and allegedly being accused of a crime? This balance of anonymity in court cases, where the person bringing the allegation is given anonymity but the person accused is not, is causing a lot of disquiet now as more and more cases come to court, fall apart, and questions are raised. So, to join me, here to help us work out right from wrong, progressive from authoritarian trends, are unfortunately not Neil Addison as advertised. He's had to attend a court case starting tomorrow. Unfortunately can't be here. But I'm sure my two panellists will make up for that. So on my left I have John Cooper. He's a barrister, scriptwriter and journalist who's written the Channel 4 series Teens on Trial. He won on behalf of the families the case against the Ministry of Defence for their provision of faulty Nimrod aircrafts. And he's just been, yesterday, recognised by the Bar Council for advocacy work representing bereaved families because of military actions. We're very proud to have him. Thanks for being here, John. And on my right is also John, Professor John Fitzpatrick, who is the director of the Kent Law School at the University of Kent. And he teaches law students by working on actual live cases, a very experimental, innovative form of teaching. The clinic has won the Times Higher Education Award for outstanding contribution to the local community, and also Kent University received a Queen's Anniversary Prize last year, and also John is chair of the Law Centres Federation, which represents 60 law community centres nationwide. So they will each in turn give a short introduction to answer the questions, are there too many laws, and what laws are problematic and why? So starting with John on my left, what's your view?
Thank
John.
you. I feel that I should be addressing the debate, are there too many Johns, the way this is going, but hopefully that will be a short debate, because we'll all say, of course there aren't, the more the merrier. Are there too many laws? Answer, yes. Question, it wouldn't, or extra statement, it wouldn't be so bad if they were good laws. But the fact is, they are fundamentally, many of them, not all of them, but many of them, bad laws. Really, what prime ministers, and not just Labour prime ministers, this goes back to the 1990s, early 1990s with the Tory government as well, and what prime ministers and government should have been told was a reversal of the old adage, don't just do something, stand there. Because in many respects, that has been the problem with legislators. There's this need to do something when perhaps stand there and absorb what's going on, think before you jump. As I indicated in that brief opening, the problem doesn't simply lie at the door of New Labour. It goes back to the Conservatives as well. And the question perhaps to ask ourselves is, why was it, what happened in 1993 that meant that the prison population then was 41,000. Only 10 years later, it became 73,000. And now, as I stand here, it may be touching 90,000. What was it that happened in 1993, as far as crime is concerned, particularly, that caused that sudden jump over a decade? It was James Bulger. That's what happened, and that was the catalyst for the welter of criminal legislation that happened. And the consequent result that the prison population over the ensuing decade went from 41,000 to 73,000 and continued to increase. That's what happened, James Bulger. It was in response to that. And not only was there a welter of controlling legislation in crime, but there was also a cascade of legislation designed to be victim-centric and legislation designed to convict. You're probably gathering here that I'm fundamentally a defence barrister, so health warning. Those are the three things that happened as a result of that instance. Since then, we have had over 5,000, if one takes the cumulative total from the early 1990s, new laws. It started with the Conservatives. Laws relating to New Age travellers. Laws relating, something close to my heart, hunt saboteurs. Actually chairman of the League Against Cruel Sports as well, which Tess didn't tell you about, which is the organisation which campaigned and drafted the Hunting Act, which abolished hunting. Laws, for instance, against other demonstrators, which were passed by the Tories. Laws which didn't need to be passed to control these particular groups. But because political instances were occurring, because there was an instance relating to New Age travellers back in the early 90s, the media were on the job as well. Sorry, Tess. Knee-jerk responses by legislators. And knee-jerk responses, I emphasise, are not just there as far as this present government are concerned. It is the problem with politicians. I'm conscious, of course, that I'm only given 5 minutes, so I'll try and put this in précis form. What about the present legislation that we have? The needless, fundamental, needless legislation in the tranche of anti-terrorist acts. Needless in many respects because the present criminal law actually is there and designed to deal with much of what the terrorism and counter-terrorism legislation was there to do. Needless detention clauses without charge. Even the police and the security services admit that it was not actually needed. Needless legislation as far as the terrorism tranche of legislation is concerned about assembly and rights of assembly. The law was already there if steps were needed in exceptional circumstances to curtail those rights. ASBOs and CRASBOs sounds like some children's programme from CCTV. The criminalisation of a class, because being no doubt whatsoever that the ASBO and the CRASBO, the super ASBO effectively, that are applied to people are generally applied to a class of people that are criminalised anyway. You will very rarely see an ASBO applied to anyone other than outside of a class of people who are already at the cutting edge of interface with the police and law enforcement authorities. Unless, of course, they happen to be a master of the hunt who got an ASBO recently for hunting. But I'm not going to gloat. Legislation, for instance, on harassment. The legislation introduced by the present government on harassment, needless. There are enough pieces of legislation and laws relating to domestic violence and domestic issues which would cover matters which transcend harassment. But all the Protection from Harassment Act has done is increase the taking or the potential taking of actions against people who effectively have fallen out into bad relationships. The misuse of legislation, and you cannot criticise necessarily the people for doing it, but you criticise the loose legislation. And let me posit this also as a bad crime as well. And this might be controversial. I don't know whether John will agree or disagree with me on this, but the legislation on hate crime. The debate amongst lawyers and academics and people generally is cut down the middle on this. Some say that it's right that there should be legislation to punish people for what they think. Others, and I generally subscribe to that view, feel that one should not be prosecuted for what one thinks. You should be prosecuted for what you do. But that may be...
No argument there, John.
That may be another debate, perhaps. Victim-centric legislation. I accept that when the legislation started, there needed to be an equalisation between victim and accused, because in many respects the victim was the forgotten party. But the welter of legislation over the last 10 years or so, in my view, has completely skewered the balance between victim and accused, so much so now we have a case like Davis that was in the Court of Appeal, House of Lords, only recently, whereby the defendant wasn't even allowed to know the identity of a person accusing him so that they could challenge that person's motives for accusing. Fortunately, the House of Lords overturned that. But it's so much so now that the legislation there to protect victims, and to many respects rightly so, has gone over that boundary now, so much so that the law now means that the accused, and notice I say accused, not the guilty party, so that the accused does not have that fair trial. Legislation, for instance, which has been passed, needlessly passed, dealing with future risk. Many of you may have seen that great film Minority Report and thought, well, this is science fiction. Well, it's heightened, admittedly, but it's not science fiction as far as new legislation is concerned. Now judges can, according to the Criminal Justice Act 2003, sentence people to longer terms of imprisonment if they feel they are a future danger to society, a future danger to society. The one great bulwark against all this, and I think this is where John and I may disagree, is what can the judges do about it? I am not a judicial literalist, whereby the judges should literally interpret the law. I am an advocate in correct circumstances for what's called judicial activism. Judicial activism whereby the judges actually correct bad law. The argument, and the rational and eloquent argument often put against this, is, well, the politicians are the elected body. But over the last 10 years or so, until very recently at least, there has been no effective opposition to this government, of whatever persuasion the situation could arise. And the judges have been the bulwark of society in testing and rejecting bad law, throwing out bad terrorist law that deprived people of their liberties, and saying to Parliament, it's badly drafted, it's bad law, take it back and do it again. Particularly in a time, and at a time, when there was no effective opposition, it was important that judicial activism was there at the forefront to protect society from too many laws, and more concerningly, bad laws. It is no surprise whatsoever that the attacks upon the judges by the politicians in recent years has been to reduce their discretion. Because, of course, the politicians do not like that law, political law, being broken. I'm told that I've got to come to a conclusion. Well, I'm not sure it's necessary for me to come to that conclusion. The debate, when we finish, maybe will come to some sort of conclusion. You notice I'm flicking through there for pages. As I'm talking, I tend to forget I'm not here to give a lecture. But the point that I do make is, where would, for instance, Pakistan and South Africa be without judicial activism? I know it's an extreme example, but the fact is, when there's bad law, when there's too many laws, we do turn to the judges to protect us from that iniquity. So, in conclusion, too many laws, yes. Too many bad laws, even worse. And I emphasise again, the watchword should be, don't just do something, stand there. Thank you.
John.
Thank you very much, Tessa, and thank you very much, Battle of Ideas, for inviting me. And thank you all for coming to the graveyard shift. 6 o'clock on Sunday evening, talking about law. That's standing up already. John Higley, the comedian, he put it very well, I think. He once said, there's hope if you're out of the house. And you're out of the house tonight.
That's another John.
I agree with a lot of what John said. We do disagree about judicial activism, and I'll come on to that. But one just very specific thing that I can't let pass, is that I think the ban on hunting was an assault on liberty. You know, freedom is indivisible. And as it happens, quite by accident, I marched with the master of the South Shropshire Hunt,
Shame.
the one who got the ASBO, because I've never hunted in my life, and I don't suppose I ever will. But I wanted to march with those people because I thought it was important that people who stood up for the non-interference of the state in what people chose to do, you know, didn't pick and choose their victims, if you like, in that respect. I have to say I did transfer my allegiance. It was accidental. I stepped in behind the South Shropshire Hunt. I transferred it later to the South Yorkshire Working Terriers. I thought it was more me, somehow.
I wish I'd never have raised it.
Is the question, are there too many laws? That's what Tess has asked us to address. And as I say, I agree with a lot of what John said, and he's in a much better position than me to talk about the impact of the detail of some of the terrible laws that we've had than I am. But I'd like to pose the answer in this way: not too many laws, too much law. I think it isn't a question of the quantity, it's a question both of the quality, John talked a lot about that, but also the very fact of, the laws that we have and the law that we have. It's difficult to find a phrase to sum it up. I've tried to talk before about the litigious society in which we live as a way of doing that. That is to say, to describe what I think is an unhealthy situation that has been developing for some time. Where we have a much greater recourse, the state and individuals, a much greater recourse to law, to regulate or to address or to solve the problems that address us both as individuals and collectively. I do think that's happening, and I do want to talk about that. I do think there is too much law, too much recourse to law in that respect. It isn't new. German scholars talked about it early in the 20th century, developing in labour law, and later in the welfare state, people like Teubner and Habermas talked about what they call the legalisation or the juridification of social spheres. That is to say, the use of law, in life worlds, as they called them, in areas of life, of social and political life, where the law previously didn't operate. And they noted the advantages and the disadvantages. And I was just thinking, and I hope she'll be here today, she was here yesterday, my colleague Helen Rees, who teaches law at Birkbeck College, round the corner. She and I organised a conference, I think nearly 15 years ago, at least 13 years ago, in West London, called The Legalisation of Everyday Life, to note this process and to talk about it. And you know something, it's got much more intense, and the process has accelerated dramatically since then. Not least, of course, because of the Human Rights Act of 1998, came shortly after, sometime after we were discussing it, and brought in 2000 a domestic form of incorporation of the European Convention on Human Rights into this country. The recourse to law, the recourse to the various legal mechanisms, there isn't one. It's particularly acute at the moment, I think, and also particularly dangerous at the moment, because it is happening because of and at a time where, society has come, in some sense, to a halt, I think in some important sense. Because you might expect in any maturing constitutional or political order, as it goes along, things will be agreed and addressed by the legal mechanisms and the norms that are reflected in law, that those will develop. But I think that what's been happening, in our society, and I don't think it's just ours, of course, it is across the Western world, there is a real acceptance, there has been a real internalisation, collectively and individually, of Margaret Thatcher's famous nostrum, "There is no alternative to this. This is it. This is what you get." And so what's happened, in a way, is it's driven, on the one hand, a need for the state to fiddle, to tweak, to regulate, to re-regulate, to remanage, to redefine, to redistribute what there is. We can't go forward, but we can mess around with what you've got, and we can tweak it, and we can provide some help here, and remedy something else there. And I think that's a very important motor of the way of just the quantity, but the quality of the regulation that we've seen. And I think what they've done is it's not simple. It's not just, obviously it can have a divisive and controlling dimension. Of course that's there. And Tessa and John touched upon the authoritarian elements and the attacks on due process, and I think both of those are there. But there's also there a desire to connect, and a desire to get information, a desire to have some conduit of communication with a society that's increasingly atomised, disaggregated, not showing any loyalty, not cohering around any commitment or even address to the state. And so it's very much something that is needed by that apparatus. I shouldn't have gone on about the South Shropshire Hunt, because I thought you would put that on my time.
That was a ploy.
Just let me mention some examples, and perhaps you can talk about them or the impact of them in the discussion. Think about the mother who doesn't look after her child at a sports day for a few minutes, and the child goes and breaks an arm on some swings. The mother sues the council, the local education authority, for £4,000. Think about the man who dives for a midnight swim into Folkestone Harbour. and paralyses himself by hitting an underwater obstacle and sues the harbour authority for not having a caution against swimming notice up. Think about the Crown Prosecution Service lawyers who charge a West Indian youth who has assaulted a black conductress on a bus and called her a stupid African bitch in doing so, charge him not only with the assault, but also with a racially aggravated assault, in order that he gets something like another year in prison on that account. Think about the historian who is accused of distorting history to deny the Holocaust and to make Hitler seem less evil, who thinks it's appropriate to go and resolve that question in a defamation action in the High Court. Think about the doctors who went to the High Court to say this mother and father should be denied the choice in the matter of whether their newborn conjoined twins are subject to an operation which will kill one of them in order to save the life of another. Goes to the court. Think of the BBC and other broadcasting regulators who think it their statutory duty to ban a party election broadcast at election time after 9 o'clock and with a warning because it will show an abortion and that would offend prevailing standards of taste and decency. Think about the lawyers, the politicians rather, and indeed the public at large who go along with them, who think it appropriate to ask a law lord, Lord Hutton, to resolve the question of whether or not the BBC was right in accusing the government of lying about weapons of mass destruction in Iraq. Now, I think all those examples have something in common, and they have this, that the law is not an appropriate tool or mechanism to resolve any of those issues. And I'll say briefly, because I've got another exclamation mark on the finish point, and I will sit down on this point, and we can expand it, I hope, in the discussion, is that the law is a very blunt instrument, and it's a binary instrument. It gives an answer, right or wrong, lawful or unlawful, legal or illegal. It can do nothing else. When a problem is brought to law, it gets that answer. One of two answers only. I mean, how inappropriate is that for an issue as intimate and as difficult as face those parents? How inappropriate is it in many of the antisocial cases that John was talking about? And one of the other consequences of that binary character of law is that it completely misrepresents also the way in which we should approach these decisions. And here we come to the democratic point. It says that some things are right or wrong, whereas the truth is they're not. Many, many very, very important policy things are not either right or wrong. They are things on which people can disagree. And the only way in which that disagreement can properly be resolved in a polity that respects the equality and status of every individual is by discussion and a vote. And the best we can get for that. Now, John's right, Parliament has been failing us in doing that. But the answer to a failing Parliament is not to say, delegate the decision further away from us to an elite of people over whom we have less control and less purchase in exercising any ownership of the decision. I've got to sit down with that.
And in my view, the important access is the accused. It's their trial, it's your trial if you are accused. It is your life, your livelihood, your reputation, your family that is on the block here, and therefore the court process is to decide on the evidence whether you are guilty or not guilty. Putting it bluntly, and in conclusion, putting it bluntly, the court now is getting confused with an adjunct of social services, and it is not.
Thanks, John.
I so completely agree with all that. I mean,
my question to you. I know.
Looking for an argument.
No, my question to you was to just draw out, as John has done, about sort of the area of policy approach to victimhood, what was good and what was bad. What do you think has been good or bad in terms of the approach to the accused?
Well, I think that the criminal process and the criminal trial is an incredibly delicately balanced operation. And the object of the exercise, the formal object of the exercise of the criminal trial, is simply to understand, for the jury to deliver its verdict, whether the person is guilty or not guilty. It isn't the formal verdict of the trial to say the person is innocent. It's to say, is this person guilty or not guilty? We don't know whether this person is innocent or not. It's whether they're guilty or not guilty. And if you think about that, the reason that is so is because the process respects that individual, and that individual could be any of us. And because the process respects the fact that our society gives that status to the individual. They have an autonomy and a dignity and a protection that they are due in our society. Therefore, they are presumed to be innocent. Therefore, the prosecution must prove its case. The burden of proof is on the prosecution, beyond reasonable doubt.
And has that been undermined by...
Well, it has enormously. I mean, it has enormously.
Just a few brief examples.
Well, one example would be the repeal of double jeopardy, that the prosecution can bring cases again. I think in another, more controversial area, in rape cases, there's been many, many tweaks in the law in rape cases. So, for example, the judge is no longer obliged to warn the jury, as the judge formerly was, in a case where there's no evidence against the accused, in a rape case, where there's no evidence other than that of the complainant. The judge used to have to warn the jury to be careful, because it's just one person's word against the other, and that could send that other person to jail for years. And that's gone. The mandatory warning has gone. The definition itself of rape has been defined, of course, as sexual intercourse without consent. But now the statute has put a burden on the defendant to show that he knew and show there were grounds in existence for him knowing that consent was not forthcoming, which again makes it easier to convict. Now, of course, there are problems about the number of of people who are raped who don't get justice. But justice isn't done when you convict somebody else, or you convict somebody who might not have done it. And that's another example.
Can I just say very quickly, and I know, but in my view, one of the most heinous attacks upon the accused has been the bad character legislation, which is brought out very briefly indeed. Now, the prosecution can allege a previous acquittal before the jury's bad character. And I was in a murder trial recently where my client was of good character, and they tried to introduce the fact that he'd been sent off in a football match as bad character. That, to me, in my view, is one of the biggest attacks upon the right of the accused, the right of the prosecution now to introduce previous acquittals, at least, to the jury as an indication of bad character.
Okay, thank you. Any questions or points? I'm going to take a round of questions and then bring the speakers back in. So starting with the man there in the grey shirt, and then after that, the man in the grey jumper.
Yeah, having been one of those dreadful parliamentarians and put through 2 private members' bills which are now Acts of Parliament, I'm not sure how much good they did, but I'll just say 3 things. I mean, one, there are far too many laws. Secondly, most are hastily and badly drafted. There aren't nearly enough skilled parliamentary draftsmen. There aren't enough, actually, of them. And the third thing is that parliamentary scrutiny is totally inadequate. I mean, when you get to committee stage of a bill, if you're on the government side, you're encouraged to bring in your correspondence and totally ignore what's being said. And you'll have the first 10 or 12 days probably looking at the first 5 clauses of a bill. Then a timetable motion is introduced by the government side, and the remaining 10 days look at the last 95 clauses of the bill. So I make my point. I just make 2, many innovations one could suggest, but 2 very quickly. One is cap the number of bills per session. And secondly, in the Queen's speech, announce the proposed bills not for the next session, but the one after, so that in the intervening year, the relevant select committee can then look at the principle of the proposed legislation, take ministerial evidence on it, and outside expert evidence on it, and then things like the community charge will probably die a natural death.
Thank you. Gentleman in the front there.
Thanks. I think on balance I can pretty safely say that I agree with John. I think it's really interesting to put this in its wider social context, which both speakers actually alluded to very nicely. The Jamie Bulger example being a prime piece in this regard. It's to do with the sort of emergence of a kind of contemporary Gothic where there is this lurking horror that can come at you from any moment, where children are potential killers, when immigrants are potential threats rather than sources of opportunity. And then the creation of us all as potential victims or existing victims within a society that's moved from community to contract, to reference the Habermasian kind of thought on that. And so what I think this does is it denies our individual agency. It puts us at a minimum level of ascribed responsibility without giving us much freedom to exercise around the margins of that. It denies community responsibility and personal responsibility. And it goes against social mediation, saying that we can actually sort out problems between people, between groups, without necessary recourse to law. And I think it's a really interesting sort of way of examining those societal trends. So thank you for bringing those points up.
Can I just ask, does anyone here disagree with the main thrust, that in fact we need more laws, or that actually some of them have been very, very good to deal with, say, personal relationships and disputes and new areas of offensive crime? No, okay.
As a lawyer, I should be arguing we need more laws, I suppose.
Okay, there's a general consensus, so maybe we should look towards what are the origins of this shift, what maybe other people have experienced, and any questions you want to put. Gentleman there, and then the gentleman in the white after that.
Well, I might not do that, but I'm going to take issue with John Cooper's conclusion in judicial activism, because I think actually you set up very well that this is a public problem and it's a democratic issue as well. So I question your resort to legalistic methods to cope with it. So I'd suggest basically that one of the most disturbing things about the anonymous witnessing argument, which we saw take place last summer, was they rushed to get through legislation. Absolutely terrifying, really, when you think about it. But what was equally disturbing was the lack of response, of unified response from the legal profession, I felt. Because I felt the debate didn't hinge on values of fair trial. It was very much hinged on practicalities. And I think that's disturbing, because I think there should be more debate within the legal profession about the legal system itself. And also a trust within the legal profession to move outside the legal system in order to solve social problems. So is it not about, one also disturbing thing about the terrorism acts was that they were publicly popular. So is it not the case that we need to reinvigorate the public's interest in civil liberties and rights to fair trial and actually show people that it's important?
Well, I know just directly answer that point,
just bring this guy in, and then a few others, and then we'll come back.
Hi, mine's also about judicial activism. I was just wondering, at what point do these judges become individual and unmediated, and what criteria do they need to use to discriminate between worthy and unworthy laws? Does it necessarily have to fall to judges, or is there another party more suited to it?
Okay. Thank you. I'm going to bring the speakers back in to make brief points, then I'll go out again, and then it will be time for summing up. So, brief points from the speakers. John, do you want to respond to this?
Okay, yeah, thanks. They're very good points you make, but one of the issues you raised there about the terrorist legislation was publicly popular. Yes, that's one of the reasons why the politicians, I have to say, forgive me, pushed it through. But the judges aren't interested in public popularity. And it allows the judges to scrutinise this sort of legislation, and whether they're popular with the public or not. No one likes laws anyway, so we're used to it. But the fact of the matter is, we don't have that pressure of public popularity, which is why the terrorist legislation has been drawn back and back and back, and properly so, in my view, by the judges. I do take your point. I understand when one says judicial activism, there's this image of pinstriped white men parading around in stockings and long wigs and trying to control us all. That's not what I'm saying. Judicial activism only steps in when it needs to step in. It's not an overriding campaign. And remember, final point, judges work on a case-by-case basis. There's no campaign by judges. They're given their case at random. They can only make the law on an individual case-by-case basis. So there's no overarching campaign by judges to change society, simply at times to nuance law and develop law without fear and a favour of public condemnation.
Thank you.
Well, I think we're getting into a very interesting area of disagreement here, and it's a very important one. And it's very interesting that in a discussion, John and I agreed on so much about there being too much law. Well, to be fair, laws, I emphasise the law itself, and John talking about the laws, that, then we come to put our faith, repose our trust in lawyers, the judges. you know, at the end of it, that they're playing a very useful or positive or progressive role. You see, I think the key to it is public popularity. What's wrong with that? That's people. I mean, who died and made us God? You know, that if the people want these anti-terror laws, they shouldn't have them. I'll give you another example.
Hanging.
Hanging, a capital punishment, is the example. You know, every single opinion poll that you can ever read, not just after a policeman or a child is murdered, but, you know, it's coming down slightly, coming down to, you know, still a very significant majority in this country of people for capital punishment. Why haven't we got capital punishment? Now, of course, you know that we know representative democracy and a delegation, and it's that people represent themselves and so on, and it's a package, you know, and so we expect things. We've got very used to things not being done that the people want because we understand how politics works. But here you've got a very, very important policy decision for a very long time, which have a very clear view of people who are as equal as you and I. They're as good as you and I. And they're entitled to their view in a democracy being implemented. And we fail them. And, you know, all that happens is those people, you know, there's this corrosive cynicism and mistrust in democratic institutions when their views are spurned. And the other thing about it is this, is that, you know, we need to argue. I don't agree with capital punishment in this society, and I think that we should argue against it. But we should argue against it with the people who will support it and try to win the argument. And if we can't win the argument, we can't then bring the deus ex machina of the European Court of Human Rights at Strasbourg to win it for us. Or these judges who will come down and say, well, you know, you can't get the staff. You know, we know what you mean. They're really thick and they're vengeful and they're horrible oiks. But what we'll do is we'll have no hanging. You know, and that is the legal position.
The judges wouldn't have approved of Guantanamo or rendition. It was the judges that actually came down against Guantanamo and rendition.
No, there's no shortage. There's no shortage of decisions that I approve of by the judiciary. They make a lot of very good decisions. In fact, one of the problems is that they'll make less good decisions because of the greater discretion that has been allowed to them, you know, since the Human Rights Act of '98 came into force in 2000. You know, and people said, oh, parliamentary sovereignty is retained. You remember it when the bill was put through in '98. Well, it wasn't. And Lord Justice Laws put it very honestly 2 years later, or 2.5 years later, in the Roth case. He said, we today, since the '98 Act, we have in this country an intermediate constitution, no longer parliamentary sovereignty, but we haven't gone to constitutional supremacy as it exists in the States. But we have an intermediate constitution. The judges have more power and discretion. It was Gibbon who said in The Decline and Fall, the discretion of the judge is the first engine of tyranny. And there's something in that. It's a completely out of place quote, but there's something in it because, you know, we can't control that discretion. They can make good decisions and bad decisions, and we won't like some of them, and I don't like a lot of them. Nothing I can do about it. They're insulated much more than the politicians from, that horrible thing, public popularity. Which is actually, isn't that another word in a way for it's a synonym in a sense for democracy.
Okay, over to the public. You, guy there, and then man in the jacket there. You first.
All right, sorry. Yeah, I just wanted to really bring in about discussion about what is the broader European context of this kind of bringing too many laws. Because one of the cases that has floored me in the past month is the guy who came to Britain and was threatened with extradition to Germany for denying the Holocaust, for an offence, I believe, wasn't... you can debate whether or not you think the Holocaust should be... denying Holocaust should be in the offence, but an offence that wasn't even committed on German soil. He had posted it on the internet. I mean, so... This
is the Australian professor?
Yes, I mean, so I'm just wondering what kind of change have occurred to make something like that possible, because it seemed to me to be very legally dodgy.
Yeah, sure. I can answer that if you need.
Well, my name's John as well, so I hope I don't confuse things too much. I'm just wondering whether I could raise one or 2 points relating to a sort of case I was involved in recently. I don't know whether it would be appropriate to say one or two things about the case.
Briefly, yes.
Yeah. First of all, if one's aware of a law one thinks is a bad law, should be repealed, what exactly should one do about it? Should one write to one's MP? Should one write to the newspapers? What should one do about it? If I could say very briefly, the law, I think, is a bad law. I don't know whether you know, I don't know whether many people know, that there's a law whereby if you leave your house unoccupied for more than 6 months, under certain circumstances, the local authority can effectively take your property away from you, something called an empty dwelling management order, which I think he was one of the last acts of another John Prescott. But the legal case I was involved in did involve the use of a threat of this in a totally inappropriate circumstance by the local authority. Secondly, I just want to ask about civil litigation. I think most of the discussion has been about criminal litigation, but this involved a case where a builder sued. It was actually my girlfriend. The builder left her house uninhabitable, and that was why it was empty, and sued her. And would you believe it? But this was a case which was ridiculous, which should never have been brought. It lasted nearly 2 years, and it was very expensive. Now, it seems to me that civil litigation has a number of these features. Often cases which are completely ridiculous are brought. It's very expensive, and it's very time-consuming. What can we do? What should we do about, the civil litigation process?
And often clogging the courts. Taking up time, which is a matter of discussion within the legal profession itself. Any other questions or points before we bring in the speakers? Gentleman here at the front, then the guy in red.
So we've been speaking about social responsibility and too many laws taking away from that. But how can we create a social system where society is responsible, yet ensure that justice is served and, make sure that people do the right thing when there's no one to necessarily answer to?
Thank you. Good question. Gentleman here.
I'd just like to ask the panel, since we are an ever-expanding world in terms of technology, take, for example, the internet and the amount of laws that govern that, and since the internet is also ever-expanding, does the panel see that that the expanding internet is a cause for even more laws to be made? We had a consensus that none of us actually feel that there aren't enough laws, but just in terms of the internet, do you feel that that is a cause for more laws to be made?
Okay, any final, very brief points so I can get you all in? This gentleman here and then the guy behind him as well. Any final points?
Thanks. In an ideal world, yes, absolutely, we would have public opinion ruling on particular issues, but two points to that. One, we actually elect representatives, not just delegates. So we actually elect them to take decisions on our behalf. They may well be better informed about those things than many people are. Secondly, living in an age when politics has been completely deracinated and the politics of vision and leadership have actually been replaced by the politics of fear, and politicians legitimize their power by protecting us from potential harms, then there is a massive danger of falling into a public opinion that has been massively misled by its own leaders, and so therefore over-legislating again.
I don't agree. As a lawmaker myself in New South Wales, in Australia, we find that we often just respond to community demand, and sometimes they are a little over the top. Last week we passed a law that said you can't walk on the road if there is a footpath, and there is a significant fine of $125 that goes with that. And some people think that's just crazy and common sense, but the problem is that we don't have a law about common sense. So in that void, we must come up with laws. So I don't know if we don't have too many already.
Okay, gentleman there, very, very brief now. Lady there, and finally the guy there. And
just to say that I think that last point was errant nonsense, because I think that there aren't these demands for laws, and I think if you look beyond the criminal law, it becomes even more obvious, the extent and depth of regulation, coming back to, I think, the very first point to the floor about the sheer amount of the stuff that's coming through, often on subjects that people have never even heard of or thought about. I actually recently drafted some legislation myself, simply because I knew someone who was drafting some legislation
They didn't know anything about it and thought that I might. I sent them some text, and the next thing I know, it's actually part of the legislation governing donations to political parties, simply because nobody knows anything about it. The law as written makes no sense whatsoever and is largely unintelligible, but people felt that they ought to do something in a very short space of time. Nothing to do with public demand.
Lady there.
I just want to say briefly something in support of the public. And I'm not sure if this is true, but I think that when capital punishment was abolished, initially it was actually done through pressure from public opinion, I think. Is that right, first of all? Right. And also the role of the jury, because the jury is where, of course, the public does come into the process of law. And there is actually an attack, I think, on the jury, sort of pushing juries out of the legal process. And my understanding, certainly if I was up in front of a court, I would see the jury as a safeguard.
I just say that I'm not sure John Fitzpatrick does understand politics, but let me just say, hang on a second, you've had your say. I think it was in terms of capital punishment. Can I just say, our colleague here is right. MPs are representatives, not delegates. And my constituents knew that I was against capital punishment, totally against it. And they could have chucked me out, but to their credit, there were a lot of things that were far more important to them than that. So every 4 or 5 years, I was up on that platform. They knew where I stood. They can chuck me out if they want to. But they didn't choose to, and they knew that in the next Parliament, I'd vote to ensure and continue the abolition.
Okay, you've got 10 seconds, and then I will bring everyone back.
Sorry, just in response to the point of the gentleman behind me, I was just wondering, should laws wait until there is an actual immediate requirement for them before they're drafted? Because surely that is what's contributing to the problem of hurried drafting.
Okay, thank you very much, everyone. We can continue this in the festival's Free Society party at the Polish Club, which after this everyone's going to 55 Exhibition Road, which is opposite Imperial College, which is where we were all last night. Please fill in your feedback forms and join the Institute of Ideas if you want more discussion, more debate, and maybe participate by setting up your own debates next year. And there's lots of debates to be generated here, and also satellite debates all over the country go on in the build-up to this conference. Meantime, I'm going to bring back John Fitzpatrick first, then John Cooper. You have 2 minutes each. John. I'm
going to race through the points. About should there be a need for a law, and you drafted a law. It was a Greek city-state, wasn't there, where if you drafted a law, put it to the Assembly and they voted against it, you were hung if they didn't pass it. So I think it was so long. It was so long. And you know something? It didn't half discourage people drafting laws. I wasn't interrupting you, ex-legislator. I mean, I was trying to find out what you said. Hear what you said. I mean, I actually said that I understood the representative character of it, and I understood that, and understood the package that people have to vote for. Unfortunately, they had to take you. You know, that was all they had apart from another party. But the problem is, people in your own position should respect. If everybody in your constituency, was or majority overwhelmingly in favour of capital punishment, you ought to. Well, you said that. You just said that. No, but I'm taking it from you. You just said that. You said you knew their view, and they knew yours, and they knew your view.
I think a judge needs to step in here and sort this out.
I think if I represent, I think obviously got rid of you. The people should respect. Politicians should respect, more what people say. The internet, I think, should be completely unregulated. With that question was asked. I also think, in response to the terrible things that people bring to civil litigation, I think there ought to be a law against it. People bring those laws. It's a whole debate unto itself, that particular issue. But the rights and responsibilities thing is a very important thing, and particularly today, of course, we see the Cabinet has disagreed about Gordon Brown's new bill to bring in a rights and responsibilities bill. Of course, as Jack Straw said in moving the 98 Human Rights Bill, rights and responsibilities are what count, and don't forget your responsibilities come before your rights. Well, that's wrong. They don't come before your rights. It misunderstands, what rights should be. But also, it does leave the important question about that, people should be responsible. But you can't, this is fundamental to my point here, you can't legislate for people to be responsible. That football commentator David Coleman used to say when somebody did something exceptional on the pitch, he said, you can't legislate against that sort of thing. You can't legislate against people being irresponsible because people, and you can't impose it on them, people take responsibility. It's not imposed upon them. If it's imposed upon them, it's obedience. It's a really important thing about the limits of the law. So that gets us back to the public opinion thing and the public. Yes, I do say trust the public more, respect them more, give voice to what they say and their opinions. And most of all, when these committees that you talk about were so ineffective, what we've got to do, we have all this responsibility, all of us, to engage with people that we disagree with, to improve the mechanisms of parliamentary democracy that we have that are not working, and above all, not to abdicate ownership of our responsibility, for what passes as law. I quote Josie Appleton, who's talking the director of the Manifesto Club, who brilliantly, summed it up. She said, justice is done, not when the prosecution is satisfied, not when the defence is satisfied, not when the victim is satisfied. Justice is done in our society when society is satisfied. And society must take that responsibility, and the way to do it is to take ownership of it and to take back some of these levers on legislation, which would make actually the passing of laws much less necessary.
I've got a good idea for a reality show, come on, let's make laws together and call it the Law Factor or something. Not that, it's that sort of. That's it.
Can I be a judge?
I like it, actually. But that is not the way to make law. But let me deal as best as I can with some of the questions which deserve answering because they're questions. A question right at the start, bad law, what do you do when you want to change it? You do what we did when hunting was legal, campaign. That was a bit of a controversial comment there, but didn't even get a gasp. So, no, the point is, when you think a law is bad in a democracy, you campaign to change it. You campaign to change it, not just through Parliament, but through Parliament, but also through lobbying and any other legitimate campaign you can have. And sometimes, might I say, that campaign can take 75, 80 years. It's sometimes long haul, but that's what you do, and it succeeds in due course, if it should succeed. Laws that are draconian, the question that was put, I think, from the same speaker about the 6-month law. Some laws are draconian, but the important thing is, within the law, built in, is a discretion that lawyers should exercise, prosecution lawyers should exercise, civil local authority lawyers should exercise, that though they have technically a right to proceed, should they proceed in the circumstances, and you rely upon sensible discretion being used. Very topical indeed. I was only broadcasting on it last week, on the assisted suicide debate. Should there be a defined law on assisted suicide? Tragic case of Miss Purdy, but nonetheless, as I broadcast and I say it now to you, no, there should not be any more definition on assisted suicide, because quite frankly, that takes away the discretion of lawyers to make a merciful decision. So again, discretion is important. Discretion of the lawyers, and I go back to my hobby horse, discretion of judges as well, to actually interpret draconian laws as best they can in a merciful way. And that's where the judicial discretion is absolutely vital. Civil litigation. There's a great trend at the moment going on for mediation and arbitration. To take matters outside of the court. I can't overemphasise from the legal profession how much we're being kind of encouraged to train as mediators and arbitrators. So there is a move to take civil and particularly lower level civil cases out of the court system. John's touched upon Bill of Rights and Responsibilities, ensuring that people do the right thing. In my view, non-starter. And I'm on the Bar Council, so I'll be considering this along with my colleagues on the Bar Council. But they'll need to go a long way to convince us that this is justiciable. I mean, there will be, well, you read it in the Sunday Times. In fact, you can't help but read the Sunday Times, can you, at the moment? It's all over the place. But you're reading the Sunday Times, valid point. It's going to clog the courts up with cases challenging whether one's economic rights, for instance, have been infringed. Internet. The big problem with internet is the jurisdictional problem as far as the internet's concerned. A lot of present legislation, including the Wires Telegraphy Act 1923, can deal with some of the issues which relate to internet. New technology, old issues. It doesn't necessarily mean you need new law. The big problem with internet is jurisdictional. Where does the action lie? Where is the item sent from? Which country can you sue in? one of the big issues, in my view, is the need for codification. Is the need for codification of the massive laws that we have. Someone should sit down, parliamentarians, in my view, should sit down, look at issues, be they criminal or civil, but particularly but particularly, I'm rushing to try and get you up to your party, but particularly criminal, whereby there's so many laws, some of them good ones, that should be codified together. Sentencing laws, for instance, into one conglomerate statute where all the law is together. That's what's needed there, codification. Capital punishment. I'm afraid to say the public wanted capital punishment. Capital punishment in this country, in my view, I wasn't around at the time, but I'll be corrected if I'm wrong by those that were, therefore no one will say it because they don't want to reveal their age. But the fact is, as far as I'm aware, the public wanted capital punishment to remain when it was abolished, and it was the parliamentarians.
Representative democracy.
Yes, it was. No, I take the point. It was the parliamentarians that actually kind of had the bravery to take that step and to lead public opinion. And I grant, obviously, I grant that argument. I can see the hand is going kind of like there. It's going to go in my mouth any minute now. But the questions deserve answers. I'm going to come to the end of them. The jury's point. The jury's point. My God, the juries are the safeguard to us. I swear by juries. But remember, it is the politicians, I have to say, who most recently wanted to abolish juries in certain cases. And I'm not saying you, but I tend to look at you instinctively as you've declared yourself. Juries, thank God for the juries. If it wasn't for juries, we would not have, in my view, for substantial criminal justice. But remember, the politicians wanted to abolish them. Laws should... Final one. I'm trying to deal with everyone's questions. So this is the last question, I think, from the lady there. About should law be made when there's a problem. No, that's knee-jerk lawmaking. That's wrong. Law, good law, preempts, which is the point that you made about more chance to consider. Sometimes parliamentarians and even judges are given such short time to consider law, you are asking for a miracle. It's very dangerous. Dangerous dogs, that's the point. There it is. Not a very structured response.
Let's thank our speakers.
Thank you very much.
Thank you both, John. Thank you.